comments. I think we've all looked to the FTC for their direction and their thinking. And as you and I know, and many others, there's a great deal of consistency over a long period of time. That actually means we can move into our first session a little bit early. As I mentioned, there is not going to be a Q&A for Commissioner Phillips, but if you have a question that's specific to his talk and you put it in the Q&A, we will get it to his office. I'm just going to give a heads up to my colleagues in the first session, and we want to make sure everybody is here. And we will actually, the first session is a regulatory perspectives and international panel. We're going to begin with Mr. Andrew Smith, former director of the Bureau of Consumer Protection at the Federal Trade Commission in the United States. Andrew?
Thanks, Bill. You can hear me, right? Okay. Not hearing any objections. Noah offered his disclaimer that he speaks, only for himself. If I was speaking to you 3 or 4 months ago, when I was still the director of the Bureau of Consumer Protection at the FTC, I would have offered a similar disclaimer that I speak only for myself, not for the commissioner, for any individual commissioner. Now, as a former Bureau director, that's doubly true. So the remarks that I offer today are, I think, those of an educated observer who was in charge of the enforcement program with respect to MLMs for a couple of years at the FTC. And I hope can offer some useful perspective on the US approach to the regulation of multi-level marketing companies. So the US Federal Trade Commission has never said that direct selling or operating as a multi-level marketing company is illegal. Direct selling is and should be a legitimate way to distribute products and services directly to consumers. It can be better than traditional retailing because it depends on direct relationships between sellers and consumers and allows companies to reach consumers that they may not otherwise be able to reach. It allows for sales to consumers and to communities who might be underserved by traditional retail. But as Commissioner Phillips said, an overemphasis on recruitment can turn a legitimate direct selling opportunity into a pyramid scheme. Similar to a chain letter, a pyramid scheme depends on recruitment of new participants to pay out to existing participants. A pyramid encourages recruitment of new participants into the business opportunity without regard to whether those new participants have a meaningful retail sales opportunity. The term that's sometimes used for this type of recruitment of multiple levels of distributors is duplication. That is the compounding of recruits that's necessary to build a profitable downline. What we see in a true pyramid is consumers paying out considerable money to participate in a business opportunity with no reasonable prospects of return on that investment. Perhaps the products being sold are not unique or valuable in any way. Or perhaps all of the potential buyers for the product have already been recruited into the program as distributors, and there are too many sellers and not enough buyers. So this is a phenomenon that the economists refer to as market saturation. Without sufficient retail demand, participants may need to purchase excess product themselves to meet the sales targets needed to earn compensation. This so-called inventory loading compounds consumers' losses. So the US Federal Trade Commission has been addressing pyramid schemes for almost 50 years. The first real pyramid case was Holiday Magic in 1974. The challenge over the years has always been to distinguish a legitimate direct selling opportunity from a pyramid scheme. One of the leading cases in this area remains the FTC's Coscott Interplanetary case from 1975, in which the FTC defined a pyramid scheme as an MLM that charges participants for the right to sell products and that compensates participants for recruitment unrelated to product sales to end users. It is this second element compensation for recruitment unrelated to product sales that the FTC said is the sine qua non of a pyramid scheme. This injury from recruitment-based compensation can be magnified by threshold-based rewards, which are rewards that begin or increase exponentially at specific thresholds, convex rewards, where greater levels of expenditure earn greater rewards, or duplication-based rewards, such as greater rewards for participants who have larger downlines. The FTC has brought more than 20 pyramid cases, including several important ones in the last couple of years, or for a couple were referred to by Commissioner Phillips. Such as the Herbalife case, the Advocare case, the Nerium case, which, as Commissioner Phillips noted, is still in litigation. In these cases, the FTC has sometimes challenged spurious product claims, such as false or unsubstantiated claims that products have specific health benefits. More often, the FTC challenges earnings or lifestyle claims. So that is unsupported and sometimes outlandish claims of millions of dollars of income or a luxurious lifestyle as a result of being a distributor of the product and participating in the multi-level marketing company. In recent cases, the FTC has looked to take action against both the MLM and the distributors for these false and unsupported claims. The FTC has taken action against the MLM for providing deceptive marketing materials to distributors or for deceiving distributors directly with inflated earnings claims most often. The FTC also has taken action against the distributors, as Commissioner Phillips noted, for the product or earnings claims that they have made directly, such as through their social media accounts or other marketing of the product or the business opportunity. Even more recently, the FTC has taken action against MLMs for the misconduct of distributors. So that means the products or earnings claims made by the MLM itself may not have been so egregious, but the distributor's claims have been truly outrageous, and the MLM has profited as a result. The FTC has said that MLMs cannot profit from deception in this manner and has taken action against them directly for misrepresentations by distributors. In addition to law enforcement cases, the FTC has a lot of other tools at its disposal, including warning letters, which have been very effective with respect to false claims that products treat, prevent, or cure COVID-19, and criminal referrals, and working with other law enforcement authorities and working with our counterparts overseas as well. I'm hoping that Katie Daffin from the FTC, who's on the next panel, will talk about some of the FTC's recent efforts. False and unsubstantiated products and earnings claims are important to address. But could a direct selling opportunity be a pyramid, even in the absence of these independent law violations? Remember that the sine qua non of a pyramid scheme is compensation for recruitment unrelated to product sales. Encouraging aggressive recruitment of a downline without a retail sales opportunity adequate to earn the promised compensation is the source of the inventory loading and the other consumer injury described earlier. Sophisticated pyramid schemes may not themselves misrepresent earnings. Rather, they set the wheels in motion with a compensation scheme that rewards recruitment over product sales, and then they rely on the downline distributors to disseminate false earnings or lifestyle claims, enabling the company itself to claim ignorance of the falsehoods. The key to evaluating whether an MLM operates like a pyramid scheme remains the compensation plan. A pyramid compensation model is one that requires distributors to recruit others to recoup their initial expenses and to seek to achieve earnings from the venture. Like a chain letter, it is frequently mathematically impossible for most of the distributors in the scheme to achieve even modest earnings. In the Advocare case, the FTC pleaded the law violation for the maintenance of this compensation system as follows. The FTC alleged that defendants operate or promote participation in an unlawful scheme in which participants pay money to the company in return for which they receive the right to sell products, and in return for recruiting other participants into the program, the right to receive rewards which are unrelated to the sale of products to the ultimate users. The FTC alleged that the operation and promotion of this type of scheme constitutes a deceptive act or practice in violation of the FTC Act. So there are a variety of responses by companies that are charged with being a pyramid scheme. One argument is that the company sells unique products and services that customers want, and therefore offers distributors a meaningful retail opportunity. Companies also respond that revenues are derived primarily from purchases by end users, not from purchases by distributors. They respond that the required costs of participation, for example, the cost of starter kits, et cetera, the costs to become a distributor are very low. Or they respond that the MLM itself doesn't make deceptive earnings, lifestyle, or product claims, and that the distributors who might make these claims are independent contractors. Ultimately, however, these arguments might be beside the point if the key to a pyramid scheme is compensation. Pyramid schemes often adopt complicated compensation schemes with a variety of rewards for achieving different goals. At the end of the day, however, if distributors are compensated based on recruitment, particularly if that compensation scheme relies on threshold-based, convex, or duplication-based rewards, the risk of consumer injury is increased, even where the MLM offers actual products. So I wanted to close on what I think is an optimistic note, and that is the advent of the Direct Selling Self-Regulatory Council. So this is a self-regulatory, an independent self-regulatory program that has been funded by the MLM industry with the Council of Better Business Bureaus, and it's designed to monitor multi-level marketing companies for unsubstantiated earnings and product claims. And it's also designed to handle complaints from competitors and consumers about these same issues. So the Direct Selling Self-Regulatory Council doesn't address the structural or pyramid issues that I discussed earlier. It won't review compensation plans or other information to determine whether any particular MLM is structured as a pyramid. But as I say, it does address and crawl for earnings and products claims, which is important because this is a real challenge in the context of MLMs, where distributors might make a wide variety of claims through a diverse array of forums, and most particularly social media. Effective self-regulation of this sort benefits everybody. It helps remove deceptive claims that may injure consumers, helps remove those claims from the marketplace more quickly than would be possible through government enforcement or legislation. And also gives industry a forum to quickly and agilely respond to marketplace changes. The National Advertising Division of BBB National Programs, the advertising industry's self-regulatory system, is a great example. NAD has been around since 1971. NAD makes referrals to the Federal Trade Commission, and the FTC staff reviews the referrals and recommends enforcement actions where appropriate. Seems to me, again, speaking in my personal capacity only, that the Direct Selling Self-Regulatory Council is a great first step to addressing the issues of earnings and product claims by multi-level marketing companies and their distributors. So with that, Bill, I will turn it back to you and our next panelist.
Andrew, thank you so much for those comments and based on years of experience that you had at the FTC. Our next speaker is, we will now move to Commissioner Gabriella Musclo. The commissioner's opinions are her own and do not necessarily represent those of the Italian Competition Authority. Commissioner, thank you for being here.
Thank you, Bill. Good morning, good afternoon, good evening, everybody, wherever you are. And I would like to thank the College of New Jersey for organizing this conference and inviting me. Multi-level marketing is an innovative business tool that indirectly benefits consumers by avoiding the high distribution costs associated with retailing. However, the improper use of this tool may raise several issues related to consumer protection, especially when it turns into an illicit pyramid scheme. As I will explain in more detail during my speech, in Italy, the boundaries of the legality of multi-level marketing have been drawn mainly by the Italian Competition Authority's case law on the basis of Italian Consumer Code. Therefore, the regulatory framework will be my starting point. In the absence of a specific regulation, protection against pyramid schemes was originally sought through the fundamental principles of contract law, nullity of a contract for illegal purposes, fraud, and so on. Moreover, the protection accorded by Law 129/2004 concerning franchising agreements was interpreted extensively to cover such unlawful arrangements. Nonetheless, a situation in which the participant of the scheme was not a consumer could not be addressed in this manner. Subsequently, Law 173/2005 on door-to-door selling and pyramid sales introduced a prohibition on recruitment schemes, the violation of which was also subject to criminal persecution. The aim of the law was to prohibit sales practices in which the main economic incentive is recruitment rather than marketing skills. Specifically, Article 6 sets out the factual circumstances under which a pyramid selling system may be presumed to be a pyramid scheme. These include the obligation to purchase a stock of products without the possibility of returning any unsold items, the entry fee, and so on. Directive 29/2005 concerning unfair business-to-consumer commercial practices explicitly states that pyramid selling is a misleading commercial practice which is, to all intents and purposes, considered unfair. It's the so-called blacklist. The directive tackles practices consisting of establishing, operating, or promoting a pyramid promotional scheme where a consumer gives consideration for the opportunity to receive compensation that is derived primarily from the introduction of other consumers into a scheme rather than from the sale or consumption of products. Pursuant to the directive, a legislative decree 146/2007, modified the Consumer Code and included pyramid sales among unlawful commercial practices. Moreover, the rules laid down by Law 173/2005 were partially repealed as regards B2C relationships. This means that the pyramid sales regulation is twofold. When the distributor is at the same time a consumer, the Consumer Code applies. When the distributor is a business, Law 173 applies. This double-track regulation raises some issues. If a consumer is held liable for engaging in a pyramid sale, an administrative sanction applies. Whereas, if a business is held responsible, a criminal sanction applies. This can raise inequality issues. Furthermore, in the first instance, the Italian Competition Authority is entitled to protect consumers against unfair commercial practices. Instead, the crime in violation of Law 173 falls within the competence of criminal courts. Moreover, the implementation of the directive led to the adoption of a legislative decree, Legislative Decree 145/2007, which modified the regulation of misleading advertising, but only as concerns B2B relationships. After this brief introduction on MLM regulation, I will focus now on the differences between multi-level marketing and pyramid sales, quoting a landmark decision by the Italian Administrative Supreme Court. Multi-level marketing can be defined as direct selling, often in the form of door-to-door sales, in which the distributor, the so-called sponsor, while marketing a product, at the same time recruits other distributors among his customers, encouraging them to sign a distributor agreement. The distributor's remuneration, however, derives predominantly from the sales volume and only to a small extent from the sales of his recruits. Both multi-level marketing and franchising contracts can turn into an illicit pyramid sales scheme if consumers are persuaded to enter the business with the promise of huge profits simply by bringing in other consumers. The two main particularities of this scheme are: first, the compensation does not derive from the sales volume, but only from the recruiting activity. Second, the entered is obliged to purchase a stock of supplies in advance as an entry fee, which is the main income of the undertaking. This means that in the absence of efficient economic activity, the economic contribution of its participants is the only means to generate enough revenue to finance the remuneration promised to consumers. The sponsor benefits from a royalty both on the initial purchase of goods and of the sales of his recruits, the direct downlines, as well as on the sales of his recruits indirect downlines. The higher the hierarchical position, the greater the royalty and the more downlines the salesperson gets. The reason why pyramid sales are deemed illegal is that once no more recruits enter the scheme, the result is market saturation, and only the lower levels of the pyramid will carry the cost of the entrance fee, since they will not be able to pass it on to newer recruits. This means that, in contrast to the promises of huge profits, compensation depends upon chance and is aleatory. Moreover, pyramid sales are often promoted through misleading advertising, both terms of profit expectation and product quality. Distributors are often trapped into the scheme due to their information asymmetry and economic weakness. The spread of these sales schemes has increased at an exponential rate thanks to social networks, which play an important role in reaching potential recruits. According to the European Court of Justice, the prohibition of pyramid promotional schemes is based on three common conditions. First, such a promotion is grounded on the promise that the consumer will have the opportunity of making a commercial profit. Next, the realization of that promise depends on the introduction of other consumers into the scheme. Finally, most of the revenue used to fund the compensation promised to consumers is not the result of a genuine economic activity. In short, a pyramid promotional scheme constitutes an unfair commercial practice only where such a scheme requires the consumer to give a financial consideration, regardless of its amount, for the opportunity to receive compensation that is derived primarily from the introduction of other consumers into the scheme, rather than from the sale or consumption of products. In In addition, the European Court of Justice specified in another judgment that the link between the contributions paid by the new participants and the compensation received by consumers may also be indirect. A recent decision of the Italian Supreme Administrative Court sets out the factual circumstances that should be assessed in order to distinguish pyramid sales from multi-level marketing, which partially departs from the European distinction. The case was the Organo Gold Europe. It relates to the marketing of coffee beverages containing a Ganoderma fungus, which is claimed to have particular therapeutic properties, through a system that encourages the participation of consumers as distributors. Consumers could register on the Organo Gold website, paying a 42 euros entrance fee, after which they could obtain further benefits and bonuses through the purchase of special packs. Compensation would result from the recruiting activity and the volume sales that the sponsor and his downline would make. However, compensation was subject to additional conditions, including monthly purchases of products for self-consumption. The Italian Competition Authority qualified the conduct as an illicit pyramid scheme. Besides the fact that the alleged therapeutic properties of products were fraudulent, and based its assessment on a series of relevant circumstances. First, the necessity to pay an entry fee and to purchase special packs. Second, the recruitment of new consumers as the means to recoup the initial investments. Third, the obligation to purchase products every month. Fourth, the small percentage of distributors that actually made some profit. The authority's finding of an illicit pyramid sale was confirmed by both the Administrative Tribunal of Latium and the Administrative Supreme Court. According to the latter's decision, the distinctive element between multi-level marketing and pyramid selling is the main objective pursued by the undertaking. Pyramid sales, indeed, the main objective is the recruiting activity rather than the selling of goods and services. In other words, the financing of a scheme derives mainly from the entry fees paid by the recruits as opposed to their sales volumes. Therefore, the very existence of the system is dependent on new recruits coming in, which should increase indefinitely. Other factual circumstances that have been considered are the need to regularly buy products to remain an active distributor and to recover the entry fee through the recruiting activity. The same assessment was conducted in the Italian Vemma case, confirmed also by the Administrative Tribunal of Latium in 2017, concerning the marketing activity of a variety of beverages. It is interesting to note that only last January, the FTC sent a second round of refund checks to people who lost money on an alleged pyramid scheme operated by the same Vemma nutrition company. As is known, the case was settled in US. However, in its complaint for injunctive relief, the FTC alleged that Vemma operated as a pyramid scheme that compensated affiliates mainly for recruiting other rather than for retail sales based on legitimate consumer demand for the products, thereby resulting in a substantial percentage of participants losing money. In conclusion, multi-level marketing is a very current and evolving topic, even more so for its frequent exploitation in e-commerce, and in e-commerce during the COVID-19 outbreak. Although Italy has not adopted any guidelines to address this issue, as I illustrated in my intervention, the Italian Competition Authority, in the exercise of its competence in the consumer protection field, has been very active in this monitoring of multi-level schemes that could turn into illicit business practices and harm consumers. Therefore, his case law has become a benchmark for MLM industries in the country by identifying the boundaries of such a peculiar marketing activity. Thank you for your attention.
Thank you, Commissioner. It's clear from your comments that many of the issues, including business structure, compensation, retail sales, et cetera, have relevance in Italy and I'm sure other parts of the world. And we appreciate your time. Next, we have Mr. Paul Hanna. He's the Deputy Director, Competition and Consumer Protection Commission in Ireland. Paul?
Thank you, Bill. I'm hoping you can hear me okay. Just going to share a couple of slides.
Just fine. I can hear just fine.
Well, Bill, first of all, thank you for hosting this conference. I'm hoping it's certainly going to be beneficial for everyone that we can learn this weekend. Now, I should have a few slides appearing on everyone's screen. Okay. Good afternoon from Ireland. My name is Paul Hanna, as mentioned by Bill. I'm the Deputy Director of Criminal Enforcement in Ireland's Competition and Consumer Protection Commission, which is an independent state agency responsible for ensuring compliance with and regulation in competition and consumer protection legislation. I've been with the organization since 2016, and I certainly, one thing I would say is I've been to many conferences organized by the European Commission in Brussels around competition and consumer protection legislation. I've been to many white-collar crime conferences and fraud prevention conferences, but never one which is featured on multi-level marketing. So this is hopefully going to be a conference we can all learn from. I will say that, in terms of multi-level marketing, and including permit promotional schemes, there is a lack of knowledge and understanding of this subject, particularly within the law enforcement world. I am an investigator first and foremost, and the role of any investigator is to gather evidence. And in seeking to gather evidence, you're seeking to establish the truth. In Ireland, we simply don't know the truth about multi-level marketing and its links to permit promotional schemes. It is a particular area of challenge, and certainly within the area of white-collar crime, it's one of the most difficult areas we've had to investigate and effectively trying to find enforcement outcomes. Let's go to the next. Irish legislation is a transposition of the EU directive on unfair commercial practices regarding business to consumer dealings, and Section 64 defines a permit scheme as a scheme by which a person gives consideration money and money's worth, or gives a gift and money's worth for an opportunity to receive compensation derived primarily from the introduction of others into the scheme rather than from the supply or consumption of a product. The one thing about reading this definition is it's not straightforward. It's one of these ones that would certainly feel that it should be one that would feel the plain English campaign, and it's one that certainly it does cause a degree of confusion for people to understand what is a permit promotional scheme. The consequences of being involved in a permit promotional scheme: it is a criminal offence in Ireland for a person to establish, operate or promote a permit promotional scheme. It's also a criminal offence to knowingly participate in such a scheme. However, this will be deleted by 2022 by the Consumer Rights Bill, which is coming through, and it will look at different aspects of consumer protection legislation. And it's also a criminal offence to induce or attempt to induce another person to participate in such a scheme. Now, if you're involved in a permit promotional scheme, you can be arrested, interviewed, and if convicted, you can face a fine of up to €150,000 or up to 5 years in prison, or both. By the fact that we have a tariff of up to 5 years in prison gives us certain powers around how we can investigate this particular offence. Many consumer protection offences that we look at, in fact, breaches of consumer protection law, don't have that level of 5 years in prison, such as the seriousness, but it does give us an opportunity to use certain powers that aren't available in other areas of consumer protection legislation. I'm just going to talk about sort of multi-level marketing impacts on Ireland. In Ireland, we see the same multi-level marketing companies that operate elsewhere in the world, with many having their headquarters in the United States of America. The beauty and health products dominate the MLMs, followed by the foreign exchange or cryptocurrency type MLMs. Some of the MLMs we have received complaints about have registered addresses at the big corporate law firms in Dublin. We have seen MLMs targeting specific minority groups in Ireland. One such case, called M Goldex, was popular among the Filipino nationals in Ireland working in healthcare, and following inquiries by our office, a warning was issued by which was enough to disrupt this scheme. But certainly we are aware that within certain minority groups in Ireland, multi-level marketing is exceptionally popular. Last March, Ireland went into its first lockdown due to COVID-19 and remains in lockdown, with many businesses still closed. These include most hotels still being closed. Hotel meetings are an important part of launching multi-level marketing, and we are aware that prior to the first lockdown in Ireland, hotel meetings were a regular occurrence to launch a new MLM or to bring in new members. We have pursued some inquiries by putting our own staff into some hotel meetings to observe what is happening in them. We have not seen an emphasis on recruitment at the meetings that our staff have attended, so it has left us with an unknown as to what is happening within some of the multi-level marketing, but we follow complaints and investigations. Everyone who contacts our office with information concerning a suspected pyramid promotional scheme, and the majority of the pyramid promotional scheme allegations or complaints invariably are linked to multi-level marketing, but everyone who contacts our office is contacted. I must say that in terms of the volume of complaints received by our office, less than 1% of the 45,000 complaints received by our office concerned multi-level marketing stroke pyramid promotional schemes. So it's less than 1%. The 45,000 complaints would equate to, I think it's just shy of 3 million complaints if it was the United States of America. So in terms of the volume of complaints we received into our office, the majority of them are not about multi-level marketing or pyramid promotional schemes. In any investigation, speaking to people is essential to establish what has occurred. However, the majority of the complaints we get about multi-level marketing come from people who don't want to speak to us again or not prepared to give us a witness statement. We can treat people who are involved in multi-level marketing as a potential whistleblower or protected disclosure if they're not prepared to give a witness statement, but it seems they are afraid, and some report to us of fear of being bullied or harassed. We're also aware that the complaints received may not be alleging pyramids, but more focused on the nature of the product and that they are potentially unsafe, such as food supplements or skincare products. In Ireland, there are separate agencies that deal with food safety and health products, and we would liaise with these respective agencies concerning these allegations. We also aware of complaints made to Advertising Standards Authority in Ireland concerning adverts on Instagram about claims about beauty products. In terms of social media platforms, they certainly are challenging in terms of progressing investigations. Investigations by very nature are difficult. The nature of MLMs is that it's done by way of messaging others from personal accounts on Facebook or Instagram, but it's difficult to assess the information and to gather all the information that is necessary. In many investigations I've been involved with in the past that are not concerning multi-level marketing, where we have to gather a search warrant or an inspection and gone into a company, we gather all the relevant material, which may include downloading millions of emails and reviewing the product. It's not that straightforward where we can simply go to a social media company to get all the relevant messages or emails, but certainly in terms of progressing cases around social media, it is exceptionally difficult. I'm really saying there is, in many cases, insufficient evidence gathered to consider a prosecution, not just a prosecution around permit promotional cases, but also around other breaches of consumer protection law. And it principally goes back to the lack of witnesses and lack of witness cooperation in many cases. It is unclear to us why people are unwilling to speak to us. I'm just going to talk about a campaign that we ran last year. We had noted an escalation over the past 2 years regarding suspected pyramid schemes that certainly promoted beauty, health, and wellness products. In light of the pandemic and the loss of employment and income, we suspected the companies of interest to our organization were targeting vulnerable people, mostly women, who were looking to earn extra money. We engaged our media company and we set up a campaign to alert people to the potential risk of joining a pyramid scheme, that they were likely to lose their money and could even get a criminal record. The campaign was run last May 2020 using digital display ads on Facebook and also on Instagram. It targeted a broad audience of women aged 18 to 50, living in Ireland with interest in social media, being a stay-at-home mom and looking to make money. The two ads that appeared are the ones shown from the scary face on the left to the euro symbol on the right within the pyramid. The two ads certainly were appearing in the timelines of anyone logging onto the Facebook and Instagram accounts. The targeted nature of these ads and the information we received back indicated these ads were seen numerous times by people who were active on multi-level marketing companies, and certainly were ones that we would suspect may be linked to pyramid promotional schemes. The ad with the scary face was less successful than the one with the euro symbol on the right. The objectives of that campaign was to increase awareness. And certainly we feel from the amount of data received back, certainly from the metrics in relation to the visits to our website and from information provided by Facebook and Instagram, was these were certainly viewed numerous times and did increase awareness. We were hoping to discourage investment in such schemes. We can't quantify that particular matter, whether there was people discouraged from investing, but certainly, it's difficult, that sort of thing to establish. We were hoping to seek potential witnesses to come forward. As mentioned earlier, witnesses are very difficult to cooperate or to cooperate with any investigation, and we didn't see that witnesses coming forward, or certainly complaints coming forward to us following that campaign. But we did see a fairly significant increase in visits to our website. There was a 23-fold increase in the number of visits to our website around multi-level marketing and pyramid promotional schemes. So we, in our view, saw some degree of success with this campaign. Using the fraud investigation model, which concerns disruption and prevention strategies, it does provide with us an alternative tactic of disrupting potential pyramid promotional schemes that may be linked to multi-level marketing. I have nothing further to add, so I'm going to hand back to Bill.
Thank you, Paul. And if you can unshare, and can you unshare? Let's see, where are we? There we go. Lovely. Okay. Our next speaker comes to us from Canada, and it is Mr. Russell Jutlaw, the Assistant Deputy Commissioner for the Competition Bureau there in Canada. Russell?
Thank you, Bill, and thanks very much for the invitation to join today's panel. It's a pleasure to be with all of you here today. In my remarks today, I'll be covering the following main areas: the mandate of the Competition Bureau and the law in Canada as it relates to MLM plans and pyramid schemes. I'll also briefly discuss the Bureau's written opinion program regarding proposed business activity. Right at the outset, I will note that the views that I'm expressing here today are entirely my own, and they don't represent any policies or positions of the Competition Bureau, nor any other entity such as the Department of Justice and the Public Prosecution Service of Canada. Okay, so first a few words about the Canadian Competition Bureau. The Competition Bureau is an independent federal law enforcement agency that ensures that Canadian businesses and consumers prosper in a competitive and innovative marketplace. Our basic operating assumption is that competition is good. It's good for both business and for consumers. And shared compliance is a key concept that the Bureau has embraced. The Bureau, the legal and business communities, and the broader network of enforcement agencies all have a role to play in promoting compliance with the law. The Competition Bureau believes that having access to accurate and truthful information helps Canadian consumers and businesses protect themselves against fraud and deceptive marketing practices. The Bureau is responsible for the administration and enforcement of the Competition Act, as well as 3 labeling statutes. And our Deceptive Marketing Practices Directorate investigates criminal and civil deceptive marketing practices that hurt consumers and competition in the marketplace. All of the Bureau's work on multi-level marketing and pyramid scheme provisions are handled by this directorate. So in our discussion today, or in my comments, I'm going to focus on the Competition Act and specifically the multi-level marketing and pyramid scheme provisions. The Competition Act in Canada has both a civil and criminal prohibition against false and misleading representations. The MLM and pyramid scheme provisions are criminal provisions. The penalties on indictment are a fine in the discretion of the court and up to 5 years in jail on conviction. And on a summary conviction, the penalties are a fine not exceeding $200,000 and up to 1 year in jail. One thing that I want to reiterate is that the Bureau is a federal law enforcement agency. We are not a regulator, so we do not regulate MLMs or any other business in Canada. However, there are some provincial licensing agencies that require a positive written opinion from the Bureau in order to obtain a direct seller's license. And I'll discuss the written opinion program in a few minutes. So let's start by discussing what is an MLM plan in Canada. Subsection 55(1) of the Competition Act defines an MLM plan as a plan in which a participant receives compensation for the supply of a product to another participant, who in turn receives compensation for the supply of the same or another product to yet another participant in the MLM plan. And so basically an MLM plan in Canada is a plan with 3 or more levels, an operator and at least 2 other levels of participants. A legitimate MLM plan focuses on the supply of products rather than the recruitment of prospective participants into the plan, and it offers products that consumers value and are willing to purchase. And so I think there are a lot of similarities there with some of the other comments that we've heard from my co-panelists. The Competition Act sets out certain requirements or obligations relating to compensation disclosure by MLM plan operators and participants, and failure to comply with these obligations is subject to criminal penalties. In essence, in order to comply with the MLM provisions of the Competition Act, the plan operator or participant has to provide prospective participants with fair, reasonable, and timely disclosure of the compensation actually received or likely to be received by the typical participant when making representations relating to compensation. And the Competition Bureau has enforcement guidelines. They're available on our website that provide some additional guidance on what is meant by the typical participant. I should note that this is not simply 50% of participants or the rank with the most participants, but rather typical participants are those participants who fall within the smallest range of compensation earned by over 50% of participants. So I want to be clear that MLMs are not illegal in Canada as long as they remain compliant with the Competition Act. And the vast majority of MLM plans that we see at the Bureau follow a legitimate business model. So how does an MLM plan differ from a pyramid scheme? Section 55.1 of the Competition Act defines a scheme of pyramid selling as an MLM plan with one or more of the following features. The plan requires a payment for the right to receive compensation for recruiting others into the MLM plan. So there's compensation for recruitment, or it requires purchases as a condition of participation other than a specified amount of product at the seller's cost for the purpose of facilitating sales, or it includes inventory loading, or lastly, the plan lacks a buyback guarantee on reasonable commercial terms, or participants are not informed about the guarantee. So if it has any one of those four elements, then it would constitute a pyramid scheme. And it's a criminal offense in Canada to establish, operate, advertise, or promote a scheme of pyramid selling. At the Competition Bureau, the biggest area of concern that we see when reviewing proposed MLM plans are issues with possible compensation for recruitment. We do not accept explicit recruitment requirements within elements of the MLM compensation plan. Participants should be entitled to higher levels of compensation based on sales made by them and by people in their downlines, not the number of people that they recruit. In practice, this has most commonly been an issue in rank advancement requirements, in which, in addition to setting out personal team sales targets, participants are also required to have a fixed number of people in their downlines. So in other words, their recruits. And keep in mind that the Competition Act speaks to the right to receive compensation. And the problem with these advancement requirements is that even if a participant reaches the sales target, they won't advance in rank if they don't have enough people in their downline. So in essence, their right to receive compensation or a higher level of compensation is now tied to recruiting more people, and that's problematic. So our view is that the inclusion of a team or organization sales target implies the need to recruit without setting a fixed number of recruits, which is generally acceptable. We recognize that recruitment is a central feature of any MLM. It's how new people are brought into plans or for expansion into new markets. So with this in mind, we generally allow for more of a recruitment focus in revenue streams with the inclusion of elements such as team commissions, for example. But we do take issue with revenue streams that are based on an explicit number of recruits. So turning to written opinions, as I mentioned, the Competition Bureau has a written opinion program. Section 124.1 of the Competition Act allows parties to request a written opinion from the commissioner with respect to proposed conduct before the requester engages in it. We do not require anyone to obtain a written opinion before operating an MLM, but as I noted earlier, some provinces do require them in order to obtain a business license. Written opinions for proposed MLM plans have a 6-week service standard, and they cost $1,000. Written opinions are binding on the commissioner for so long as the material facts, and I'm quoting here, on which the opinion was based remains substantially unchanged, and the conduct or practice is carried out substantially as proposed. So it's important to note that a written opinion is not a pronouncement that the proposed conduct is completely legal or illegal. This doesn't mean that the proposed plan could never be investigated by the commissioner down the road, or that it wouldn't be referred to the Public Prosecution of Service of Canada, or that they wouldn't lay charges. It simply means that if the material facts that the opinion was based on remain substantially unchanged and the plan is carried out substantially as proposed, then it wouldn't merit a more fulsome inquiry under the Competition Act. As I mentioned earlier, the Bureau believes in shared compliance. So our view is that we all have a role to play, and it's easier and it's the more efficient to address an issue before it becomes a problem. So if a written opinion is to be issued, we may have a more detailed discussion afterwards with the requester in order to explain why the written opinion was, the negative opinion was issued. And this may help businesses in making further amendments if they wish to submit a second written opinion request. I also want to note that although our requests for a written opinion may be for the MLM or pyramid scheme provisions of the Competition Act, we will still check to see if the proposed conduct raises issues under other provisions of the Act, for example, the general false or misleading representations or performance claim provisions, or other statutes that we enforce. And if those, if there are issues that arise and those other issues don't have any bearing on the assessment of the proposed MLM plan, for example, performance claims about a product, then the review wouldn't lead to a negative opinion, but it could result in the Competition Bureau refusing to issue an opinion. The Bureau may also refuse to issue a written opinion if it's determined that the proposed plan is already operating, unless it's needed for provincial licensing requirements. So in addition to the written opinion program, the Bureau has enforcement guidelines, as I mentioned, on the website. And the Bureau also helps to lead Canada's Fraud Prevention Month. And we work closely with a number of partners each March with tips and education pieces for consumers and businesses. And this year's Fraud Prevention Month included social media posts to help educate and alert consumers to look out for pyramid schemes and how to learn the difference between legitimate MLM plans and illegal pyramid schemes. So to wrap up, I hope this provides some insight into the Competition Bureau's role as a law enforcement agency with respect to MLM plans and pyramid schemes. This concludes my remarks. Bill, I'll turn it back to you for further discussion. Thank you.
Thank you, Russell, and thank you for sharing the environment there in Canada. I'd like to ask all the panelists to turn on their cameras and their microphones. We do have time for some follow-up questions. And as they're doing that, I would again mention to the attendees, when you look down at the bottom, you should see an icon that says Q&A. And you are more than welcome to post a question. We have Doug Brooks monitoring those questions. And when I get done with the follow-up, when I get done with the follow-up questions with the panel, then we will move over to that Q&A period. So the first, is Andrew Smith on yet? Yeah, there he is. Okay, for the first follow-up question that I have here, and again, these are not questions coming through the attendees, these are follow-up questions the panel and I have discussed prior. So this first question is for Andrew. It's actually 3 clustered questions that all pertain to each other. Are all MLMs pyramids, or could there be MLMs that are not pyramids? Are you aware of any MLMs that are not pyramids?
So this is an important question, I think. You know, it's what all of us have been talking about, is the distinction between legitimate direct sales and a pyramid. And I would say I was interested in Russell's comments where, you know, in Canada, where they have this system of licensing or registration, where there actually are business models and compensation models that are reviewed. And I was encouraged by Russell's comments that most are compliant with the Canadian rules. So we don't have that sort of a system here in the US with registration or licensing. My impression, though, is that there are thousands, if not tens of thousands, of multi-level marketing companies and that and that many of them may be doing it right. I have only my perspective from the FTC, where we brought those cases historically against those companies. I would say that again, the key, and it seems like everyone agrees on this, that the key is to look at compensation, in particular compensation not related to product purchases. So do you have a program, for example, where distributors have to recruit to advance in the business or to earn certain types of compensation? That might be the type of favoring of recruitment that might lead an agency like the FTC to conclude that you are that you're that you're too focused on compensation and straying into the area of being a pyramid. But I want to be clear that the FTC and I personally believe that direct selling is legitimate and a good way to distribute products to consumers. And the FTC has always said, and Commissioner Phillips reiterated this, that it's not per se illegal. So I do believe that there are direct selling firms out there that are not pyramids.
Thank you. And Commissioner Muscolo, what role did the issue of retail sales play in the recent case handled by the Italian Competition Authority?
Thank you for your question, Bill. The case I have chosen for our audience dealing with this issue is the My World Italia, Lyconet Italia case. In that case, the authority recently assessed an unfair business practice of creating a shopping network designed to engage a wider range of consumers and affiliates to take advantage of cashback incentives to shop in an online marketplace. In particular, what happened? By agreeing to the Lyconet marketing program, consumers could become marketers who promote the programs. The compensation plan established 8 levels of remuneration according to the number of shopping points acquired through direct purchases of Lyconet products, recruitment of our consumers who enter the system to buy the products, purchases falling under the cashback mechanism. The practice was qualified as pyramid selling because career progression and maintenance depended primarily on the purchase of special packs of Lyconet products and the recruiting activity, both of which granted higher numbers of shopping points. In contrast, the purchases falling under the cashback mechanism, which would constitute the real economic activity, the retail sales, played a limited role since they conferred a limited amount of shopping points and required more efforts. This means that the system relied on the monetary contributions of the participant, direct purchase of Lyconet products by the marketers and easier downlines, rather than on real business activity based on cashback, making the continuous growth of the network essential. Since Lyconet products do not play the role of promoting the marketer's business activity as claimed, they can also be regarded as the entry fee necessary to finance the expected compensation. In addition to this, a great number of marketers did not recoup the amounts spent on the direct purchase of Lyconet products. From the payment schedule, it emerges that out of 25,000 to 35,000 participants, around 5,000 to 10,000 participants were losing money. Less than 1,000 marketers made a profit about 1,000 euros. Only 153 exceeded 5,000 euros, and only 2026 surpassed 10,000 euros. This was the evidentiary basis for the decision of the case. Thank you for your attention.
Thank you. And I think increasingly we are gathering the kind of data we need for that kind of analysis. Paul, in Ireland, the MLMs you are aware of may be headquartered in the USA or other jurisdiction. Do you see difficulties with investigating MLMs which operate from a different jurisdiction?
Simple answer, yes, Bill. In terms of progressing this, and one of the things is our near neighbour, United Kingdom, obviously we've had to engage with them over different multi-level marketing pyramid schemes over the last couple of years. And one thing they'll say to us again as well, because it's done on probably a basis around trading standards bodies in England and Wales, is that they'll tell us that if the persons are headquartered or the MLM has been run from the United States, invariably because of a matter of resources, priorities, etc., they will not progress sometimes some of these MLMs. For us to progress an MLM that is outside our jurisdiction, if there's suspects or the persons involved in it, or even some of the witnesses are outside the jurisdiction, our state prosecutor in Ireland, the Director of Public Prosecution, has probably got more likely to be not supportive of progressing or support of progressing a prosecution if a lot of the parties are outside the jurisdiction. For us to progress a request outside of without a formal agreement. Now, within the EU, we have the CPC network, which is Consumer Protection Cooperation Network, which allows for easier exchange of information within the EU countries. Obviously, UK is now left following their Brexit decision last year. But if the MLMs are in the United States, we have to go through a mutual legal assistance treaty, MLATs, which is a fairly cumbersome process. It's also a very slow process. We would have to put a request through our, Department of Justice, which we then have to send to US Department of Justice to get that information necessary as part of the. And it's not just a simple case of we want to know certain specific details. It's a more, we would have to have a very strong case to be looking for that information in the first instance. And it could be rejected, certainly to be sent across. So in terms of when the companies are outside the jurisdiction, it does create that challenge. I would say probably about at least 50% of the MLMs we would be looking at a subject of complaints are headquartered in the United States of America, and it's probably, as what Andrew said earlier, I would think probably some of these MLMs are not breaking the law. That we might have complaints, we might have information, and I know some of the comments people come back saying, well, witnesses don't want to come forward. But in any investigation, we need people to tell us what is happening within an organization or within a business. We can't investigate simply on social media alone and rumors and anonymous sources and whatever else. We need to have people telling us either within the business, protected disclosures, witnesses. So in terms of the difficulties of investigating matters which is outside our jurisdiction, yes, absolutely, it does create that difficulty. So for yourselves, probably in the United States, where the companies are operating, you have probably a lot more of the witnesses, people involved in it, and headquarters. That's certainly easier because for us, some of the options open to us is to consider searches or an inspection. Now we can do inspections of business premises, and we use inspections in relation to other consumer protection as well as competition matters. We can't do an inspection of a private dwelling, but if that business has been operated outside the jurisdiction, we then would have to request the relevant country to then seek to possibly carry out an inspection or search. Within the EU, that is possible. Outside the EU, it's a bit more difficult. So.
And what options do you have? I know you just mentioned inspections. If criminal investigations and prosecutions are not effective?
I think for us, the whole issue of, we have so as mentioned on the slide show I put up there, we've used a communication campaign effectively. You know, we like in terms of, you know, the actual complaints we get into our office, you know, most of them don't probably get the level of contact or engagement that the multi-level marketing complaints get, because of the serious nature potential of what's involved. So not everyone gets contacted with regular complaints to do with consumer issues. So everyone who contacts our office will be contacted, but it's such a small amount, as I said, less than 1% result in complaints about multi-level marketing. So we have put a strong emphasis on communications, and certainly from our website, our engagement with the media. We had a pyramid case just last month. Now, it wasn't multi-level marketing, but it was a pyramid case. It went viral across certain social media platforms. Now, we are progressing that particular matter with the social media companies to identify who was involved in it. But for us, I think disruption and prevention strategies are another area that we can look at, because it does provide us an alternative tactic, i.e., can we put out warnings? Can we disrupt them? Can we possibly take down websites? I think sort of if we have a website which is promoting a product, and there might be complaints about it, you know, we certainly can go to the web host if we can look to possibly take that website down. I think I mentioned Facebook and Instagram in references. They are probably the two biggest companies responsible for promoting a lot of the multi-level marketing that we get complaints about. And if they had a bit more of a reasonable approach to what's been posted on their sites, that perhaps they could make a difference, and really for probably a stronger engagement with law enforcement and ourselves.
Thank you. And the data you cited on your public service announcements was pretty impressive in terms of the impact. Russell, do you have any tips for businesses in developing their MLM plans in order to comply with Canadian Competition Act?
Yes, thanks, Bill. There are a few things that I'd suggest that businesses do regarding their MLM plans to increase compliance with the Competition Act in Canada. First, review the Bureau's MLM plan and schemes of pyramid selling enforcement guidelines carefully. As I mentioned, these are available on the Bureau's website. Second, if you decide to apply for a written opinion from the Bureau regarding a proposed MLM plan, be sure to provide all relevant information and materials. And this includes, for example, advertising materials that have been developed, or if there's like a website, provide that. We use a trust but verify approach, and this means that we ask for some underlying data and information to verify what's submitted. So, for example, provide the data on which you're basing the typical earnings disclosure upfront, so that we don't need to request that later. If you're using, for example, compensation figures from another jurisdiction as a starting point for a proposed plan in Canada, then we'll likely be asking why, how is that jurisdiction similar? And again, it's best to provide that information up front. Third, it's important as well to read your own materials carefully, especially the terms that are being used. For example, if a compensation plan refers to a bonus breakdown, has that been provided? If there's a document, for example, called a bonus chart, then we're not going to assume that that's necessarily the same thing. And lastly, be aware that if a written opinion is requested under the MLM and pyramid scheme provisions, we will still check if the proposed conduct raises issues under other provisions of the Act or other statutes that we enforce. And as I think I mentioned earlier in my comments, that where those other issues don't have any bearing on the assessment of the proposed plan, that review wouldn't necessarily lead to a negative opinion, but it could result in the Bureau refusing to issue an opinion. I think I'll leave it at that. Thanks, Bill.
Sure. And any tips to potential participants?
Yeah, for sure. In terms of tips, the tips that I'd suggest for prospective participants, those that are thinking about signing up for an MLM plan, first, before signing up, research the business, check different websites, consult many reviews, and if something seems fishy, then walk away. Also be aware of multi-level marketing plans that promote huge profits using only their highest earners as examples. Remember that in Canada, they need to disclose the compensation that's actually received or likely to be received by a typical participant. Also, we recommend watching out for plans that have compensation, MLM plans that have compensation plans focused on recruiting new members, or plans that don't include a reasonable buyback guarantee or a refund policy that would allow you to return or send back extra products at the end of your engagement with them. If they don't provide it proactively, then ask to see it. And plan operators do need to disclose that. In addition, our advice is to watch out for plans that make some sort of attempt into buying excessive quantities of products. At the end of the day, as I mentioned earlier, MLMs are legitimate business models for product distribution, but they do need to make proper disclosures of earnings and compensation. And prospective participants need to be aware of those requirements. And obviously, they need to stay away from illegal pyramid schemes that are focused on recruitment and saddling participants with untenable sorts of conditions. So those are just a few of the pointers that I'd suggest for folks that are considering participating in an MLM plan and to be wary of regarding illegal pyramid schemes.
Thanks so very much. And thanks to everyone. That kind of concludes our panel portion. I'm going to actually make an executive decision and suggest that we end the session at 10:55 instead of 11 o'clock. That will give us a whole 15-minute break instead of a 10-minute break, as we are running well on time. I'm actually going to turn this over to Douglas Brooks now. He's been monitoring the Q&A, and he'll pick up a few questions that are of interest to our attendees. Doug?
Yeah, thanks, Bill. There are quite a few questions. I'll try to put them into categories. One issue that a number of people have raised is the issue of costs that distributors incur in addition to product purchases, business expenses, going to meetings, and certainly in the U.S. there are reports of some high-level distributors making more money selling sales aids than they are in the actual MLM. And I'll throw this out to any of you that want to answer this. Have you looked at that phenomenon? Have you studied it? Do you have any data regarding that, and any position regarding recovering those funds for distributors?
So I think that, this might be a good question also for the next panel of folks who are engaged actively in law enforcement as well. But I think that at the FTC, historically, the FTC has looked for sort of, compensation that's all in, what would be representative, and it would be net of the expenses of a representative participant, net of the expenses of that participant in the system. And so if you're going to be disclosing an overall compensation figure, that ought to be representative in every respect, at least in my opinion. So I don't know if other folks have things to add on that.
Thanks, Andrew. I was struck by Paul's comments about the difficulties of getting witnesses to come forward, and I think there is a broader phenomenon of people who have been in MLMs who are reluctant to talk about their experiences. but there is this phenomena of people posting about their experiences on social media. Has that made that, has that improved the situation regarding witnesses coming forward? Do you guys monitor those comments, or do you wait until people come forward and actually complain to you?
I think, Douglas, we normally wait for people to come forward to speak to us. You know, like people do send us links to different social media sites, but you know, like we really can't carry criminal investigations based on what's on social media, which could be incorrect, could be false, but also, you know, we really need to speak to people. Speaking to people is a key part of any investigation. I know some people are thinking, why, you know, people do want to speak. You know, this thing of, you know, they feel that they're under threat or going to be harassed. I certainly can't understand, and I go draw a parallel that, you know, and I don't want to come across as you know, insulting to anyone, but like, you know, if you're an alcoholic, you really have to admit to being an alcoholic before you can seek help, whatever. And again, if you're involved in a multi-level marketing scheme, and we see people going from one to the other, they say, I'm not happy with that one because I see the product being sold, or there might be recruitment, and I don't like the nature of it. But then they leave it and they go to another one. And to the extent that, you know, I see the material coming into our office, and we see people who complain to us about one particular multi-level marketing, and then they're appearing in a subject of a complaint and a separate multi-level marketing complaint. So, you know, it's a difficult area for people to come forward. I don't understand this cult-like fascination that people have who are in multi-level marketing, you know, in terms of threats. And I mentioned I worked in counterterrorism. I worked for 10 years. People give witness statements in terrorist investigations. Members of the public give, and there's a greater threat to them. There's not that level. People say they may be subject to abuse or whatever else. You know, people are involved in multi-level marketing lose money, and sometimes lose lots of money, lose friends and family. So like, I just don't understand the inability of people to come forward to engage. But you know, we can't simply investigate from what people post on a blog or some kind of thing. And we get anonymous messages into our office. We don't know who these people are, but I can't go to a judge and say, Judge, we have anonymous information. It comes from somebody on Twitter or Facebook telling us the following. We need to have somebody telling us, and we need to be able to send over the credibility of that person. You know, and again, one or two complaints about a company is not sufficient for us to be progressing an investigation, to look to take down a company or investigate a company which could be legitimate. We simply don't know. So we need credible information. We need credible people, and we need to know equally about the background of these people. And you know, I think there's certain vulnerability. The people who are involved in some of the multi-level marketing that targeted at females that I've mentioned earlier, you know, I don't think these people perhaps would be working in high-pressure jobs, probably somewhere else. You know, they're at home. They're consumed by social media. They believe they have hundreds of friends on social media. Like I say, I don't have hundreds of friends, and certainly most people only have 2 or 3 close friends. And I think there's this unrealistic world that they have around them, around social media. But it is a difficult area. But for any investigation, and I've been involved in multiple investigations outside of multi-level marketing pyramids, this without doubt is the most challenging in terms of getting people to come forward to speak to us.
Thanks. It's certainly something I get asked a lot by people. What's the best thing I can do? What can I do to you know, get some action? And I always say, go to the regulators. Go, you know, file your complaint with. I mean, obviously here's the FTC and the state attorney generals, but I always encourage people to do that. But there is, I'd say, more than in any other type of frauds, fear and shame and embarrassment. But that doesn't make your job any easier. I can see that.
I think Douglas, if you look at the numbers involved, and you know, we don't know the full extent of people involved in multi-level marketing companies in Ireland, but we certainly are aware that there's thousands. There is as many, like, Irish people love social media. They love being on Facebook and Instagram, and I am aware there's obviously a high number. The people in Ireland are probably as much aligned to the American view of life and making money, and they want to be successful than probably the European approach to life. But if there's thousands of people involved in this, we're not getting thousands of complaints. So the smaller number of complaints we see in the office, as I mentioned, less than 1% of the total number of complaints we receive in our office, which is 45,000, most around other areas of consumer protection.
Yeah. Thanks. There are a number of questions about the significance of retail sales, and
could you speak up just a little bit?
Sure. There have been a number of questions about the significance of retail sales. And let me ask each of you, do you distinguish between retail sales to people who are not part of the plan, and then sales to participants in the plan, what the industry sometimes calls internal consumption? And I'd hope each of you could speak to that issue. Does it matter whether the person who is buying the product is also a participant, a distributor, versus someone who is truly outside the plan and just a consumer? I apologize for my voice.
So I think that in some of the FTC's recent resolutions of MLM cases, there is a distinction made between a retail customer and a customer who's also acting as a distributor. So there is, I think when evaluating sort of the overall, when evaluating whether there is compensation for recruitment, you would want to look at sales to people who also are distributors. And so, in looking at sales targets and the like, monthly, are distributors purchasing, at the end of the month in order to make some sort of a monthly overall sales goal in order to earn compensation for that month, those types of issues. So I think that there is, just as a practical matter, a distinction between sales to people who are not distributors and sales to people who are distributors, insofar as those distributor sales might be a function of the compensation for recruitment. And the FTC also, in cases, and I think other regulators as well, look at issues around if you're purchasing for your own personal use, does it make sense? Is it possible to use that much product in the appointed period of time?
Russell, is that an issue for you in Canada? The distinction between internal consumption and sales to bona fide consumers?
Yeah, I mean, in Canada, under the Competition Act, the reference there is really in terms of the compensation received by typical participants, likely or actually received. And so, I'm not sure that I can say that there's a distinction drawn there. It's really in terms of the compensation in terms of either of those two sources.
And Paul or Gabriella, do you?
The issue was not at stake in Italian cases, not specifically. However, as already mentioned, in the Lyconet case, the retail sales had some relevance because they were defined as the real economic activity of a phenomenon, but not really the question you have raised.
Andrew, you talked about,
Wait, Paul, did you have anything on that?
No, I think it's been covered.
Andrew, you talked about the industry self-regulatory council and I think the Better Business Bureau. Is there data about the efficacy of the work that they're doing in terms of and is what they do publicly available? I mean, can we find out what complaints they've acted on and what's happened as a result of those complaints?
I do not know the answer to that question. And I can look while we're here. I do think that they contemplate this being an active program where there are public metrics reported and there are regular referrals made to the Federal Trade Commission in the same manner as the BBB's National Advertising Division. So I'll take a look and see if they are and see if they report out anything publicly. But other panelists too today, and later panels may have information about how the DSSRC operates. And it was founded, as I recall, in 2019, and of course the last year has been sort of a funny one in terms of activity. So I don't know, they may still be sort of getting their sea legs at this point.
Maybe last question, Doug?
Sure. We've got, as I said, we have quite a few here.
Maybe two more. I'm just watching our time. Let's shoot for 10:55 to close out.
Yes, so Doug, it looks, I'm just looking at the DSSRC website, which is on bbbprograms.org, and they do have a list of decisions and administrative closures, and there are quite a few of them here, a lot. So it seems as though they've been fairly active in investigating claims.
Thanks. Sorry, folks, I'm just scrolling through here. There's been I know one attendee asks about social media companies that have banned MLMs on their platforms. I think there was an issue with TikTok recently. Do you think that's a good trend? Is that something that, and I know, Paul, I think you addressed this to some extent, but is there some way of accomplishing this rather than the platform moving on its own, but is there some process that can take place that would rein in some of the bad operators on social media?
I think, as you mentioned, TikTok have banned multi-level marketing. There's obviously a Chinese company, and maybe they see it as probably where they have difficulties in their own country, that China will embrace multi-level marketing, much like other countries. There is very much cultural differences around the world and around how people engage. And you look at the figures, the likes of, I know in Italy, there's probably more stay-at-home people who are stay-at-home women who may be looking to make revenue. I think sort of some countries have less of a target audience. People's access to social media and the growth of it. I can't foresee the likes of Facebook and Instagram carrying on with the current approach to just hosting these and not looking at the impact that it's going to have on certainly in terms of other issues. Because if you look as how they're they respond to complaints, and like Facebook and Instagram have a lot of people looking at the coverage around hate, racial aspects, and the whole issue around, probably misleading advertising. It's one of the issues, probably doesn't feature as much, but if they're promoting products that have dubious claims about health and well-being, that's maybe an area which we need to be more focused on. But again, we're focusing on permanent promotion. It's going to take probably for other agencies from food standards, health products to be more engaged with the social media companies. They are, certainly Instagram and Facebook are two of the biggest companies in the world. I would like them to be a bit more responsible. I personally would like to see them probably not hosting these adverts and these messages from these companies. But at the moment, over the last 12 months, they've had probably that opportunity where people are spending more time with social media, and it has been an effective platform for these companies to expand.
Well, thanks. Bill, should we wrap this up now, or?
I think we will. First of all, I want to again thank our panelists, we very much appreciate your participation. I believe this is the first time ever, certainly the first time that I know of, and other people that I know who have watched this industry, to bring together regulators from other countries to talk about this. We recognize, of course, that different countries have different perspectives, different cultural and economic environments, but conversations are good, and learning from other experiences are good. So again, thank you very much. I'd like to remind our attendees, we will reconvene at 11:10, and our next panel is Federal and State Enforcement Perspectives here in the United States. We have people from both the federal and state level. I think you'll find that engaging, and as Andrew mentioned earlier, these are the enforcement people, are the people who have to make the call, who develop the investigative techniques, and it should be a very interesting panel. Again, thank you all, and we will see you everyone at 11:10.